Hello, my name is Anjali Kauster, and I am the CEO for the Cupertino Chamber of Commerce. And I would like to welcome you to our webinar titled Options for Businesses During and After COVID-19. Now I would like to introduce our speaker, Vinod Nichani, Principal for Nichani Law Firms. Mr. Nichani's combination of legal and business experiences gives him the ability to approach legal matters from different perspectives to provide the most effective solutions. His practice is dedicated to business litigation and bankruptcy matters. Mr. Nichani's clients include individuals and small to medium-sized businesses locally and around the world. On a lighter note, Vinod grew up in Cupertino and graduated from Monte Vista High. He then attended San Jose State University and received his law degree from the Lincoln University in Oakland. With that, let's turn over to Vinod.
Good morning. My name is, like she said, Vinod Nichani. I have spent most of my life in Cupertino. I practice bankruptcy and business litigation because I believe both those practice areas kind of go hand in hand, especially when it involves a business. I'm used to doing this presentation live, so I might throw my hands up or jump around, but I'll try to do that on the camera, not too far. But I'll keep the outline. I welcome all questions in that this is an interesting topic right now, and I want to keep the discussion as fluid as possible. Every question is important because it could apply to the person asking the question or a friend of theirs. We don't know, but it can help me expand on examples. If I make any mistakes, I apologize. I'm getting used to the whole internet way of doing seminars. Okay, so we're in unprecedented times, the times of COVID. And during COVID, the biggest things a business can do is plan ahead for, plan for the worst, but hope for the best. But I think the key component of that statement is planning. Now, before we even get to the discussion of planning, I think we have to know that we don't know what the future holds. We don't know if the shelter in order is going to really come back up a month from now, maybe 2 months. I know I just read somewhere that they're going to allow golf courses to open, which is exciting because I'm not very good of a golfer. I can spend some time, playing, but we don't know what's going to happen. But we know it's going to open eventually, and we know that businesses are suffering right now because they can't really operate. So some of the things we want to do is really just understand what options are available, whether bankruptcy is the tool that is necessary right now. And, I really look at bankruptcy as a tool. It's really a way to reevaluate a business and find out whether it's time to shut down, time to reorganize, or time to come up with a different plan. Okay, so what I'm going to do is I'm going to start here with sharing my screen, and let's see if we can kind of expand on the discussion on what I'm talking about here. So if you think of bankruptcy, you think of a kind of a circle, or partial, and inside that circle is your business. And during this time of your business, you're operating, and business has slowed down due to the pandemic, and creditors are starting to call, and they want to get paid. So the first thing is you're going to be getting calls from maybe your landlord, calls from the IRS, taxes, calls from vendors, and then, miscellaneous different people that are owed, companies or people that are owed money. What bankruptcy does is it gives you that ability to stop the calls until you figure out a resolution. Now, in a typical situation, a client would come to my office and say, I have 5 restaurants, and due to the pandemic, I can't operate these restaurants. What do? I have to pay rent, or the landlord is going to evict me. I don't have sufficient funds coming in to pay the rent. What are my options? In a normal situation, my response would be, well, if you want to keep the company alive, if you want to keep your restaurants alive, we need to contact the landlord and coordinate some kind of payment plan, and if not, file a bankruptcy. But in the COVID time, I wouldn't really push a bankruptcy because I just don't know what's going to happen a couple of months from now. So what I would suggest in this small time period are a few things. So if we draw a timeline that right now it's going to be May 1st, I'll put that there, the 1st, and then this is July 1st, okay? If I were to give you an approximate time to file bankruptcy, I'd say file in July. Just an approximate, okay? But I would say during this time is where you would spend the most of your time planning. Okay, now July is not a guaranteed time. It's going to depend how aggressive any of your creditors are. But if we're going to be planning, there are a bunch of things we would want to review by yourself or with your attorney, which would dictate when you would file bankruptcy if you were to file, okay? So that would bring our discussion now to two components. The first component being, what are things we would think about before we file, such as alternatives, such as documents we need to review at home or in our office, employee issues, things like that. And then if we go the bankruptcy route, what are the bankruptcy options? Okay, so let me erase this here. So if you have a business, you have many things you're dealing with or items you have to review. So the first thing would be is what I title as pre-bankruptcy planning. So let me write that over here. And I'm sorry if I jump around a lot. There's just so many issues that I'd like to bring up, and I don't know if 1 hour is to kind of the time period to talk about everything, but let's call this topic pre-bankruptcy planning. Okay, so this is before a possible bankruptcy. The first thing is, what kind of business do you have? Is your business an sole proprietorship? Is it an entity? Is it a corporation? Is it an LLC? Those are things you need to find out. Now, the subcomponent of that question is, if it's a corporation or an LLC, do you have all your books and records in place? For example, in the LLC, does the LLC have its operating agreement in place? Do you have a binder where you can access all those documents? If it came to filing a bankruptcy for that LLC and you were to come to my office, I'm going to ask you for all the documents related to this LLC. How long would it take you to gather those documents? Those are things you want to start putting together. Now, if it comes to you being a corporation, you're going to have your corporate bylaws, you're going to have your articles, but do you have all your annual minutes and resolutions in place? Those are things that I'm going to look at to kind of see the history of this corporation. Now, why are those important? The whole reason you formed a certain entity is to protect your personal assets from liability. So if we go and bankrupt a corporation or LLC, we want to make sure there's a distinction between you and that entity. And one of the biggest components for that is you having all your compliance documents in place. So you want to make sure all that, go ahead. I'm sorry, Rick.
Vinod, yeah, Rick Gibson with the Chamber of Commerce. We're starting to get some questions.
Okay.
And you're talking about corporations and especially with all of the stimulus money that's been coming through, I think this is going to be relevant to several people.
Okay.
The question is, as an S Corp and having received PPP and EIDL, they find out that they are still not able to make it as a profitable entity. What are the consequences?
Well, I don't have the answer on how PPP funds or EIDL would be treated in a bankruptcy. I imagine it's not going to be considered an asset or funds, but if you've blown through those funds, then you're still going to be in the same situation, which is considering a possible bankruptcy filing. I mean, at the end of the day, if the money coming in doesn't support the operation of the business, you still have to consider a bankruptcy. Does that answer the question? Or can I respond? So. Can I respond directly to the questioner and ask him if it answers the question?
Yeah, I can do that while you're continuing your presentation.
Okay. So anyway, so as a corporation or LLC, there's more requirements to stay in compliance, and that gives you the ability to to separate yourself from the entity. Now, if we were to take a step away for a second from bankruptcy in general, anybody who has, you know, a corporate entity, an LLC, you have to keep in compliance. Because if I was a creditor, or if I were to bring a lawsuit against the company, if I was a company suing your company, one of the causes of action I have is something called alter ego. And what that means is that I can pinpoint that the individual and the company are one person or one company, and I can go after personal assets. So that's why, regardless of bankruptcy or a lawsuit, you want to keep that distinction. Okay. If I'm confusing you, send in the questions. Okay, the next thing, which sounds pretty minimal, but a personal guarantee. Now, when a solo files a bankruptcy, it doesn't matter because the solo and the company are one. Their liability is going to be the same. The obligation is going to be the same. But if the entity files a bankruptcy, that doesn't absolve the liability that's owned on the personal guarantee. So, for example, let's say you have a gentleman named, I don't know, Donald, and Donald goes ahead and gets a loan for his company. Now the lender is going to ask Donald, hey, you know what, Donald, this company is way too young and has no credit. We want Donald to personally guarantee this loan. Okay. So the company defaults and the lender says, okay, the company can't pay. We're going to go after Donald. Same situation applies. If the company files a bankruptcy, then they're going to go after Donald individually for the money. Now, this is something you need to find out in advance during your period of pre-bankruptcy planning. So if you come to my office and say, hey, I want to file bankruptcy for the company, we have to make sure and know whether or not a personal guarantee exists on the individual. That way I can advise them and say, look, maybe you can file bankruptcy for the company, but we want to figure out what to do individually for the liability that comes your way. And if you have assets, you want to protect that. So that might be in a situation where we bankrupt the company, but the individual negotiates some kind of settlement with the creditor, or puts together a payment plan, or figures something out. Because in the end of the day, we don't really care about the bankruptcy for the company. We don't want the personal assets to be touched. Okay. Another thing is, which is really, really difficult, I find, for small companies, is accounting. Your books and records accounting have to be clean and organized. Because if you file a bankruptcy, there are going to be numerous other parties looking into your company. There's going to be creditors looking at any transactions with the company that's happened within the last 90 days of the bankruptcy filing, within a year of the bankruptcy filing. There's going to be a third party called a trustee that, for the benefit of the creditors, is going to be looking at all the transactions within the company. And the reason for that is they're trying to find out if any funds of the company has been hidden away or transferred away that should be brought back to the company to treat these creditors fairly. So, for example, if we go back to the same example I had, so I'm just trying to, okay, we're back on the whiteboard. Again, you got the company over here, and you have the individual over here. Okay. So if a creditor comes in and says, hey, you know what? The company owes me $1 million, and the company files a bankruptcy and says, hey, we have no assets, go away. The creditor is going to say, well, yeah, we can go away from the company, but now we can sue the individual. Okay. And the individual is going to have to deal with this debt. So that's something where personal guarantee is very important to review and discuss before considering a bankruptcy filing. Now, the next thing to consider with the bankruptcy is going to be something where I just brought up, books and records. Let's say, for example, company files bankruptcy in January 1st of 2020. Now there's a look back period. If we look back here, for 1 year, let's say. And instead of paying creditors, the company has decided to only pay the individual. The creditors are going to come in and say, hey, wait a minute, why is the individual only getting paid and we're not? So they can bring an action to sue the business or maybe even the individual in the bankruptcy filing. So that's why we have to take a lot of time to review the time period prior to the bankruptcy filing. And if you're considering a bankruptcy to be filed in the next couple of months, now's the time. I know operations are difficult. I know business is tough, but now's the time to review everything to make sure that even if you file the bankruptcy, it doesn't end up hurting you down the line. So, in other words, it's all part of bankruptcy planning. Now let's, I have to keep a track of time because I can go forever on this topic.
Vinod?
Yes.
For people who haven't been through the process, can you very briefly go through the differences between the different chapters?
Yes, we're going to get to that right now.
Okay, great.
Okay, so what I'll start with, I'm going to start with kind of a day in the office, meeting with the attorney, how it goes, and then thereafter we'll discuss the different types of bankruptcies, okay?
Great, thank you.
So to keep it really simple, a client contacts me. It's either through a referral from another attorney who represents them in a form of litigation, or maybe a lawsuit or disputes that are happening between two parties, okay? Or someone contacts me saying their house is going to be foreclosed or the business restaurant is going to be foreclosed on. Or someone who's been basically just suffering financially and they can't keep their expenses up. Right now, what you're seeing is a few different types. You're seeing real estate being foreclosed on, and that real estate could be owned by an individual or a company. You have situations right now where, because of the laws have been changed in the labor law system, where companies can no longer pay everybody as an independent contractor. They have to pay them as a wage and hour employee. That has increased the costs for businesses and they can't operate anymore. And as a result, they've been sued by employees for past retroactively. So basically what's happening is employees are saying, hey, wait a minute, you know what? You treated me as an independent contractor for the past 5 years. I'm going to sue you for the past 5 years of wages instead. And that ends up being $500,000 or $1 million in attorney's fees that end up accruing. So the company says, hey, why do I want to keep doing this? I can't afford this. So they come to my office to discuss bankruptcy. So I receive a call. What I do usually is I talk to the individual or responsible party and I send them a list of documents that I need to see during our initial meeting. And that list of documents for an individual could include an asset and liability list, a copy of all bank account statements, a copy of any outstanding debt, such as credit cards or personal loans or mortgages, and they bring those documents to our meeting. Now, if it's a business, it's going to be, like I mentioned, for a corporation or LLC, we'll need the operating agreement of the bylaws, any resolutions. Both individual and companies, I'll need to see their latest taxes. So there'll be a list of documents provided prior to the meeting. Now, the potential client would bring those documents to the meeting or forward them over to the office. And at the first meeting, we kind of have a review and discuss financially what's happening. And at that point, we would say, hey, you know what? There's two forms of retention in my office. The first form of retention is going to be pre-bankruptcy planning and advice. And the second form of retention could be bankruptcy filing. So right now we're getting more pre-bankruptcy advice because we don't know if we're going to file bankruptcy. So what I say is, hey, why don't you retain this office for pre-bankruptcy retention? And what that means is if they start getting creditor calls or they have questions regarding how to basically be they have questions regarding what they should do in their business up until a possible filing. So that's pre-bankruptcy retention. Okay. Or for example, if creditors start calling them, they can say, hey, call our attorney. So then the creditors call me and I tell the creditor, hey, leave them alone. We may file bankruptcy. So that's pre-bankruptcy discussion, negotiation, things like that. If down the line they realize that we need to file a bankruptcy, we've kind of done all the homework during the pre-bankruptcy stage and we can file bankruptcy. Or at our first meeting, they come in and say, we got to file, we don't have time, we don't want to spend attorney's fees anymore. Attorneys are expensive, they're a pain to deal with, I get it, you know. So those are things we have to discuss at that point. So that's the first meeting. Then the second meeting is where we have drafted, if we're going to go for a filing, we have drafted the schedules and we get to sit down and go over the draft schedules. Okay. Now, once the schedules are signed and filed, we file bankruptcy. Bankruptcy is filed electronically on the computer. For me, I press a button and it's filed. I can file at midnight, I can file in the morning, I can file whenever. I can file like an hour before foreclosure. I don't advise it, but I do it. So these are different things that are done. What it comes down to is what bankruptcy filing is the best choice for that particular client, okay? So let me go back to my share screen and see if we can kind of break that down. So what you have is, you have two different situations. Okay, I'll draw a line down the middle. You have an individual bankruptcy, or you have a commercial, which is corporate bankruptcy. Individual bankruptcies have three options of filings. They have a Chapter 7, a Chapter 13, or Chapter 11. Commercial corporate bankruptcies only have the option of a Chapter 7 or a Chapter 11. When I say individual bankruptcies, I'm talking about consumers, or I'm talking about sole proprietorships, DBAs, individuals that are doing business. When I talk about commercial, I'm talking about corporations, LLCs, LPs, things like that, okay? So let's start with the individual bankruptcies. Chapter 7, which are both the same. Chapter 7 is a liquidation. You basically say, look, I got nothing. You have nothing to take from me. Leave me alone. I'm going away. So in a Chapter 7 for an individual, the goal of the individual is to get a discharge of their debt. So in their schedules, they're going to say, hey, I have clothes, I have furniture, I have, you know, art pieces, guns, whatever you want to do, you're going to list it in a certain category. And if it comes to any assets, let's say you have a car, let's say you have a house, we have to list those. Now, you can keep some of your assets if the asset is exempt. But if I want to keep the discussion really simple, let's say, for example, you have $20,000 worth of jewelry, okay? You can keep that. But if you have $200,000 worth of equity in your house, it's not going to be fair where you file a Chapter 7 and walk away from your debt, okay? So we have to do an analysis and say, hey, okay, they have $20,000 in jewelry, but their house has no equity. Okay, we can file bankruptcy and walk away from their debt. Okay, but if you have $200,000 in equity in your house, and you can keep $100,000, assuming there's an exemption, you have $100,000 equity that's available, that's not protected. So then the trustee, who's the managing body, is going to say, well, if you have $100,000 equity in your house, that should be distributed to the creditors. So either you give me $100,000 or you sell your house and pay creditors. Okay, so if I dissect that analysis even further, when you file a bankruptcy as an individual, there's going to be a person called a trustee. The trustee is this governing person who has to look through all your assets and liabilities and find money. They got to find money for creditors. So what they're going to do is they're going to look at the assets, they're going to look at your liabilities, they're going to look at any transactions you made within the past year. So for example, if you decide the day before filing bankruptcy that you want to give $20,000 to your brother and say, hey, you know what, I owed my brother some money, I'm going to pay him $20,000. Trustee's going to say, well, why should he get the $20,000 and not the other creditors? They're looking for fairness within the transactions. So those are things we need to review before you file to make sure your brother doesn't get a phone call saying, hey, give us that money back. So those are certain things you have to consider. But in the end of the day, the goal of the Chapter 7 is to liquidate and walk away from your debt. Now, if you compare that to a Chapter 7 in a corporation, it's a little different. A corporation doesn't really get a discharge. The benefit of doing a bankruptcy for a corporation, a Chapter 7 really, is kind of two components. The first component is that you have a third party, the trustee, who looks through all your assets and liabilities and says, okay, at the end of the day, at the end of the bankruptcy, there's no assets in this corporation. I've reviewed everything. There's nothing there. So if a creditor down the line wants to sue you or the company, they're going to see that a third party already did an investigation and found no assets for the company. Okay. Some other people might say, well, why don't I just dissolve the company? You could do that. You could dissolve the company, not file a bankruptcy, but just because you dissolve the company doesn't mean a creditor can't sue you down the line and say that, you know what, I think you're hiding assets. I'm going to sue you. So when you compare the costs of hiring an attorney to represent you in that case versus just filing a bankruptcy and having a third party investigate it, it's going to be a lot more cost beneficial to file the bankruptcy. So that's a reason a corporate bankrupt might do a Chapter 7. Sorry. Okay. Now, the Chapter 13, that's called a wage earner bankruptcy. What that means is an individual or a sole proprietor who's making a certain amount of money, a certain amount of income, but they can't afford to pay all their debt immediately, they will be given the option of paying their debt back over 5 years. Now, secured debt, which involves mortgages, car loans, that has to be paid 100%. And you have to continue paying your mortgages. But let's say you owe about $200,000 to $300,000 in unsecured, such as credit card debt. Then we can analyze of whether the credit card debt needs to be paid at 10, 20 cents on the dollar or all the money, but you'll have the opportunity to pay it over 5 years. Okay, and that's only available for individuals. Now, that same analysis applies to Chapter 11 for individuals. Okay, but the difference is the only reason an individual would go to a Chapter 11 is if their secured debt, meaning their home loans or business loans, things that are secured to certain items, exceed $1.2 or $1.3 million. There's a number over there. If it exceeds that, then you have to file a Chapter 11. You can't file a Chapter 13. Or your unsecured debt is about 396 or 3, depending on the number, exceeds that, then you have to file a Chapter 11. Chapter 7s for individuals and companies are usually a flat fee. They could range from $2,500 or $1,500 to $5,000 to $10,000 in a Chapter 7. And then there's a court filing fee, which is $335. For a corporate Chapter 7, it could range from $3,000 to $5,000 to $10,000 to $20,000, depending on the case. And that also has a court filing fee for $335. Chapter 13, the filing fee is $310. Fees can range up to $10,000 to $20,000, but the benefit is the debtor, the person filing the bankruptcy, can put a down payment and pay the balance of the attorney's fees in monthly payments, along with the payments they pay their creditors. Chapter 11, not so fun. The filing fee is $1,717, and this case is usually taken on an hourly retainer. So you're looking at, so my rate is $350 an hour. If it's an individual, the deposit or the retainer would be between $15,000 to $20,000 up front, and then it's billed hourly. And then once that retainer is exhausted, the attorney can apply for more fees. Okay, and that same goes for the company bankruptcy. Now, the same fees apply. The retainer obviously be a lot more because there's more components in a corporate bankruptcy. Now, the goal of the corporate bankruptcy, similar to the individual Chapter 11, is that these bankruptcies are forms of reorganizations. What they're trying to do is keep the business afloat. You're trying to find a way where you could work with all your creditors for them to give you that time to make payments and catch up. Okay, so if I was working in a situation where I'm facing COVID and COVID is affecting my business, I would, step one, start planning a bankruptcy, and I would keep an open communication with my creditors and maybe let them know in advance, hey, I'm going to file for a bankruptcy, but we're going to do a Chapter 11 because we're going to reorganize. And when we reorganize, it's going to give us the ability to generate more income to pay our debts back over 5 years. Okay.
Vinod, there's a question I think relevant to this. How does a company pay the attorney if they're out of money?
Well,
this whole process presupposes there isn't much to work with. So how do you pay an attorney out of that?
Let me see if I can see the question.
Well, this came in from chat.
Oh, okay. So yeah, that's always the issue, is how is the attorney going to be paid? If it's a commercial bankruptcy, it's difficult because the retainers are so high up front, such as Chapter 11s. But again, in especially in the situation right now, I usually start with the client and say, look, if we're going to file bankruptcy a few months from now, and there's no urgent reason to file today, I would take a smaller retainer up front and give the client the ability to pay maybe monthly or whatever until the actual filing. Okay, because it's like two different worlds. The world now is pre-bankruptcy, and the world after bankruptcy is post-bankruptcy. Pre-bankruptcy is kind of the time you spend investigating, and maybe if we could push the bankruptcy filing out further, it would give that company time to gather the funds to pay. But yes, it's always tough to come up with a way to pay. Sometimes what could happen is you could pay up front, and then after maybe 120 days, the attorney could apply for additional fees. That's in a Chapter 11. In a Chapter 7, which is a liquidation, which you're going to walk away, then I'm sure there's a way that, again, the attorney could work with the client to coordinate a time period to make those payments. It's hard to come up with hardcore cash right now. I get it. It's just there's a structure that can be put together that can be that could apply, that could help the payments right now.
Thank you.
You know, I take cash, I take gold, I take you know, whatever you can do. Just kidding. All right. Now, I don't want to make this seminar a boring lawyer analysis, which, you know, most lawyers, I get bored within 10 minutes. I'm checked out. So that's why I appreciate the questions. But what I'd like to do is kind of go over examples, and I'm going to draw these examples out so you can see how they've applied. So if you have an example you want to email me, or something you think would be interesting, email it and I'll draw it out, my analysis. Okay, so let's erase this. So my first example involves, like I mentioned, we had a business and we had an individual. Now, the employee sued the business and said that he is owed $30K. Okay. And during the process of that lawsuit, the attorney's fees were $400K. Those stinking attorneys get paid so much for nothing. So then you have a total claim, you have a total claim of $430,000. Okay. So the business says, hey, I can't afford this $430,000. This is garbage. Okay. But at the same time, that employee says that, you know what? The books and records between the employee and the business aren't clean. Therefore, we can add that individual to the complaint. Okay, so now, not only is the business getting sued, but they don't want to go after the individual also. So what they did was they hired me, and we did the pre-bankruptcy planning. And what I did here was I was able to analyze the situation, prepare a bankruptcy. Now, all I did was I prepared the petition. I didn't file it. Two different things. I just gathered the information and I took the petition. I took the petition and I gave it to this attorney and I said, look, if you keep pressuring us and you decide to sue us, we're going to file a bankruptcy. And basically, if we file a bankruptcy, we're going to ruin your life. You're not going to get this $430,000. I'm going to make sure you don't get anything. Or, well, I'm going to make sure you're only going to get half or a third of that. Okay. Now, the attorney on the other side was smart enough and he realized that I was serious and he understood my analysis. And we ended up settling for $100,000 in payments. Now, this doesn't guarantee a result for every case, but it does portray an analysis, which is we use that possible bankruptcy filing to the creditor and said, look, this is what could happen. So why don't we make a deal before? And that deal reduced the $430,000 to $100,000, number one. And also the best part is it prevented the bankruptcy filings. Okay, because a bankruptcy filing for an individual would have been devastating to his credit. It'd be on there for years. Okay, so we prevented that filing. And also, instead of bankrupting the company, we just let it dissolve and walked away. So what this did was two components. We used the pre-bankruptcy negotiation and analysis to get a result we would have gotten with the bankruptcy filing, but without the actual bankruptcy. So that helped with attorney's fees, and it helped where the client didn't have to go through the full bankruptcy. Okay, that's one example we did over there. Any questions?
Vinod, how often is it a problem that the books between the individual and the business are not clean?
All the time. No, I'm just kidding. Well, I would say 60% of the commercial bankruptcies that I see, the books and records are not clean. That would be, they don't have their operating agreement. They don't have their annual records. They've been pulling money out of the company. They haven't been making it clean. And I see that quite a bit. So what I would do is we would have to meet with the client and actually remind them to clean their records. Number one, not cook the books, remind them to clean their records. And then number two, schedule the bankruptcy filing. So that way enough time has passed whereby if we file and a third party wanted to come after any of the money, it's too late. So it's really a strategy that has to happen before. Now, the funny thing about this COVID analysis is you're kind of pushed into a time period where you have to strategize because we just don't know what's going to happen in 3-4 months. And I would hate to push a company into bankruptcy if they don't need it. I'd rather advise them right now as to what they should do. So, for example, one of the companies I'm dealing with right now, they have a company and the landlord has not been paid for 2 months. Now, in certain situations, the landlord's not allowed to evict, but it doesn't mean the money goes away. Eventually, the landlord's going to want their money. So what I've been telling these clients is, look, why don't you connect the landlord with my office? Let me communicate with them, and I'll communicate with them and share with them that same bankruptcy analysis that says, hey, look, you keep pushing us, we're going to go into a bankruptcy. We don't have any assets, and you're not going to get paid. And if you want to get paid, I suggest you work with us to coordinate some kind of situation where in the time frame down the line, we can start generating income again and maybe pay you guys back and move forward. Because not only are they going to lose a tenant, they're going to lose the monthly income, and things are just going to get nasty in bankruptcy court. So that's kind of the analysis we use. Another example is, again, foreclosures are stalled for the time period, but if someone has a home, just because they don't have to pay the mortgage for a few months, they're going to have to pay it eventually. And at that time, the real question is, how are they doing income-wise? So if the 3 months passes and eventually the landlords start to foreclose, the individual's going to have to think about, hey, what do I do? I don't have a job yet. I'm interviewing. Nothing has happened. The economy hasn't changed. We would use a Chapter 13 bankruptcy for a few components, either to stop a foreclosure, to give them a little bit of time to generate income, borrow money, or whatever to catch up on their mortgage, or to give them time to possibly get the house ready for sale, clean it up, sell the house, and then dismiss the case. A Chapter 13 is the only bankruptcy that can be used by an individual where they can voluntarily dismiss it. So you can actually use the Chapter 13 for time periods to either decide whether or not you want to sell the house, keep the house, put something together to work with an investor or whatever it may be. But the point is, it gives that individual time. Okay.
Now, Vinod, there's a question about leases.
Yeah.
Just to clarify, can businesses get out of their lease through bankruptcy?
Yes, they can surrender. They have a choice to walk away from their lease in bankruptcy. Now, there's going to be a question if they've kind of remained on the lease after the bankruptcy, they might have to pay for that. But the pre-bankruptcy debt, they can, that becomes an unsecured claim. That becomes a claim that the landlord might want to collect on, but they can surrender their leases. And that's the best part of the bankruptcy. They surrender it. Now, again, the biggest issue is going to be, is there a personal guarantee on that lease? If the company walks away from the lease, does that personal guarantee come into play, and can the landlord collect from that individual?
Okay. Thank you.
You got it. Okay. Alternatives. Now, by no means do I encourage a bankruptcy filing if it's not necessary. I don't feel it should be done unless the absolute last resort, but that doesn't mean I don't consider it an excellent tool. Now, like I just said, to use bankruptcy to shed a lease out, that's awesome, or to use bankruptcy to reduce the amount of debt and to give a company time to build up again is a great tool in business. A lot of bankruptcies we see right now are restaurants. Okay, I have about, I would say, 10 restaurants I represent that I have filed Chapter 7 bankruptcies for, and we're still in the process of filing it. Now, some of those restaurants, the unfortunate thing is there were personal guarantees there. So I filed a bankruptcy for the restaurant, and then I have to file a bankruptcy for the individual because of the guarantee. So there's numerous situations that we review and analyze to kind of help that situation out. Now, if I say alternatives, alternatives to bankruptcy right now in COVID, the biggest alternative would be to create an open line of communication with your creditors. Now, most creditors are going to understand the situation. Most landlords understand the situation. But the problem is going to be where that creditor or that landlord needs your rental income to pay its mortgage. So these are things that could motivate them to be aggressive against you. And that's why I think you really need to start creating those communication lines. If a creditor calls you, I would advise you start asking them questions, start finding out what is the room they're going to give you to buy more time. Now, what I would do is if you're seeing yourself with a lot of creditor calls, I would start creating an Excel spreadsheet or some kind of document and getting information from the creditor. Say, if they call you, say, okay, who are you calling? Who are you calling from? Are you collecting agency from a certain creditor? Get their information, get their number, get their address. So down the line, when you meet with an attorney, we already know who the creditors are and we have the contact information. So that way, I, as your counsel, can contact them and start creating a line of communication, especially during the pre-bankruptcy period. Okay. The next thing is, like I've said before, if your books and records are not clear, clean them up, because you might find once you clean those books and records up, there may be more exposure or there may not be more exposure. Oh, sorry. Okay, I'll stop that. I'm back. Okay, let me see. Now, one thing is, if you're gonna consider a bankruptcy filing, I would also point to the fact that the day you decide that is the day you stop taking on more debt. Okay, so that's one thing I advise all clients when I see them is, okay, we've decided bankruptcy, let's stop everything. Let's stop taking on more debt and let's start moving forward on resolution. Okay, and that's difficult because a lot of individuals, especially, they're like, hey, if I can't take on more debt, how do I pay for my expenses? Well, that's where you got to start using hardcore cash or a debit card. Okay. Now, when it comes to companies, it's a little bit different because they have to operate. And if they're only operating on credit, it's really time to consider the options. Okay. Alternatively, there's probably nothing I would say that would prevent anybody from reevaluating the financial situation right now. We just don't know what's happening in the next few months. And it's really important for a company to kind of go in and connect with their CPA or connect with an attorney to just discuss options and really investigate, because especially for a company, you don't know whether or not a Chapter 7 is the way to go or a Chapter 11 is the way to go. You can always start with a Chapter 11 and you can always say, hey, I want to reorganize my debt, but let's say 6 months down the line, it's just not working out. You can convert to a Chapter 7 and liquidate the case. Okay, so there's numerous options, such as I have a case right now where I filed a Chapter 11 for a company, okay, and you know, with COVID hit, and COVID is not helping the feasibility of the Chapter 11 company being able to put a plan of reorganization, because there's just not enough income. So I'm going to try to ride the wave for a few months. If things change, then that's great. We have the ability to reorganize the company. If it doesn't, we're going to have to convert to a Chapter 7 and liquidate. Okay, versus I could say, hey, you know what? There's no future in sight. Let's just, you know, file a Chapter 7 and get rid of the case. Now, I want to touch back on something that is really important in the whole bankruptcy analysis, and it's the emotional drain of it. Okay, an individual filing for bankruptcy is emotionally very, very difficult. And it's not only just the fact that a lot of people feel, oh my God, you know, I filed bankruptcy, but it's also the involvement of the individual, you know, such as meeting with an attorney, such as going to court, such as going to hearings. Now, when an individual files bankruptcy, there's really only one hearing in a Chapter 7 or a Chapter 13 that individual is going to attend. It's called a meeting of creditors. And this meeting is about 10 minutes long, okay? So the individual goes with their attorney and they meet with this trustee person I mentioned earlier. And for 10 minutes, that trustee is going to ask questions. And the trustee is really going to interview the individual to find out whether everything on the paperwork is true and correct. So they're just looking for clarity and, you know, honesty as to the financial situation. Now, after that meeting, there's in a Chapter 7, about 100 days go by, and then the individual gets its discharge and the case is closed. Okay, in the Chapter 13, the individual has the option to have a payment plan, which we talked about, and that payment plan can go for 3 or 5 years. Okay, and during the payment plan, the attorney may attend hearings on behalf of the individual, or attend hearings with the creditors, or what may happen. Now, in a commercial bankruptcy, which is, let's start with the Chapter 7, there's only one hearing again, which is a meeting of creditors. But in the Chapter 11s, there's a few meetings that an individual or a representative of a company would attend. The first thing, again, would be a meeting of creditors with the attorney. There'll be something called an initial debtor interview, where the individual or representative of the company would have to take all the documents and kind of go over this representative of the trustee to analyze, you know, all the assets, all the liabilities, all the debt, things like that, and what the intention of the company or individual is to do in a Chapter 11 to reorganize. Everything in bankruptcy comes out to feasibility. Okay, if it's not going to be a liquidation, can the debtor, the person or company filing the bankruptcy, can they reorganize or come up with a plan of reorganization that's feasible? Okay, so whenever we're going to a hearing or whenever we're doing anything in a Chapter 11, it's going to come back to, okay, this sounds interesting. This sounds like a good plan, but can you pay it? And then the creditors are going to say, okay, well, if you can pay that, then are you going to do it? Am I going to get anything out of it? So it's a full plan of analysis that comes through. The advice I would give, I think we have 9 minutes? The advice I would give right now is that if you're even close to considering a possible bankruptcy, or you just need advice on organizing yourself in the event bankruptcy is a possibility, or you're not even going to go close to bankruptcy, meet with an attorney. Okay, you don't have to meet with me, but meet with any attorney who can review your facts and review your situation now, moving forward, and for the past year. Because this is the time you're going to have to kind of what I call load up your gun to fire, which is the bankruptcy filing if necessary. Because what happens with the filing is it stops everything cold, okay? And it gives you that time to reevaluate. But once you file, a full transparency happens, okay, with the creditors and with the courts. So if you're going to file a Chapter 7 or Chapter 11, you have to disclose all your income, all your assets, all your liabilities, and your income for the past like 6 months or a year, or even further if it's required by a trustee. So what that means, in other words, is if you're going to file something and you've done anything before that bankruptcy that's questionable with your finances, everybody's going to know about it. So it's important that all those transactions are evaluated before the actual bankruptcy filing. Now, yes?
There's a quick question for that initial consultation. Is it traditional for people to expect to pay the attorney?
I'll tell you what, I mean, in most cases, yes, but if you've attended this seminar, I'll waive the initial if you're going to come see me. Let's put it that way. But it depends on the client. It depends. I mean, most cases, if they're a consumer bankruptcy and they're like a mill, they're just doing 7s and 13s for consumers, I could see them not charging a fee, like a free consultation. But if they're a law firm that does business bankruptcies, I could probably see them charging a fee, an hourly fee. Okay. It's just the business bankruptcies have so many more components to it than an individual. You have two sets of attorneys. You're going to have the ones which are mills, like I mentioned, and they only touch the consumer bankruptcies. Then you're going to have firms that do the business bankruptcies and the consumer, like I do, and they might have a different fee structure.
Great, thank you.
Sure. That's a good question because it does get expensive. You really want to, and it goes back to the questions that were asked before. You want to allocate time to meet with an attorney, because if fees come up, you have to decide where the funds remaining should be, applied to. Should it pay for your employees? Yes. Should it pay for your landlord? Well, if he's not aggressive, maybe some time would work, but you got to pay your attorney because otherwise he's not going to do the work. And that's kind of the key here. Employees and attorneys need to get paid. So you need to sit with your attorney and figure out how to make that happen. A final note is the list of documents that the attorney provides you. It will take some time to gather. For me, I know that a lot of clients have not done their taxes, obviously, for 2019. And, the attorney's going to ask you for at least profit and losses or a balance sheet on what's been done, okay? When it comes to employees, you want to make sure and pay those employees. You can't walk away from paying employees in bankruptcy. That's not going to work. There's going to be exposure. It's important that you consider any creditors that are being aggressive with you, that you gather that information, okay? And kind of just put together a financial picture before the attorney, so that way you can minimize costs. One of the biggest problems I find is clients who come into my office and they want to meet with the attorney, they bring a bag of paperwork. It shouldn't be, you don't want to sit with the attorney and open envelopes with him. That's just going to waste time. You want to try to gather your documents and information and keep a file together, so that when you come in, you're not wasting time. Oh.
There it is.
Oh, what happened?
I think Anjali just put up a slide with your contact info on it.
Okay.
So that everyone knows how to get a hold of you.
Call me, email me anytime. I'm here.
Great. Well, thank you. I don't see any lingering questions. Anjali, do you care to wrap up?
Yes. So thank you, everybody, for being here today. And we will be continuing to do these kind of webinars in the future. And you can contact Vinod, as you saw the information on the earlier screen. And we will be, or you can visit our website at the Cupertino Chamber of Commerce and get more information and check with us. So thank you for being part of this webinar. And we're going to sign off now. Bye-bye.
Bye-bye.